Chancellor, I now ask the public orator, Professor Elizabeth Walcott Hackshaw, to present Mrs. Lynette Seebaran Sweet, whom the Senate and the Council of the University have been pleased to recommend for the award of the degree of Doctor of Laws honoris causa.
Chancellor, there are words depleted of their power to move us because of overuse or even misuse. But then special individuals come along and words such as courage, brilliance, service, and vision resonate once again. Lynette Seebaran Sweet is one of these individuals. In her many roles as lawyer, educator, and advocate, she has spent much of her life fighting for the vulnerable groups who have endured discrimination and injustice. She has heightened awareness in the national community for reform in family law, domestic violence, sexual harassment, reproductive rights, and gender policy. Chancellor, it may seem strange to say, but Seebaran Sweet's voice is not her own. No, instead, it is the voice of many who have been unable to speak up for themselves. Exceptional individuals are a combination of their innate gifts interacting with their external environment. Seebaran Sweet, the firstborn of 7 children, grew up in the rural market town of Caroni Village. From an early age, she was imbued with the ideals of public service and social justice, with parents active in the realm of politics and trade unionism. Seebaran Sweet was a precocious child, not one for outdoor life, preferring to devour the books around her home. From an early age, it was clear that she would make use of her gifts. At Holy Name Convent, she was a member of the high school's debate team and took part in the mock UN debates held during that time. After high school, she entered the Faculty of Law at the Cave Hill campus in Barbados, where she graduated with first-class honors. She then attended the Hugh Whitting Law School on a Hugh Whitting Memorial Scholarship awarded by the UWI Guild of Graduates. Seebaran Sweet was called to the bar in 1977. Recognized early in her career for her legal acumen, she had the opportunity to choose a lucrative legal path. She chose to focus on family law to fulfill an inherent desire to serve the underrepresented in the society. Chancellor, to this day, you can find her litigating in the courts, conducting family law, and her advisory litigation practice. It is remarkable that Seebaran Sweet has had in excess of 160 reported cases as the lead attorney. It is never easy to select the milestones of such a tremendous career. One of her earliest causes was in the Industrial Court, where she represented the National Union of Domestic Employees in a case brought against an employer by a domestic worker. Her work as chair of the Equal Opportunity Commission brought to Parliament a request to amend the discriminatory definition of sex in the Equal Opportunity Act. During her tenure as chair of the Port Authority Board, the Port Authority building was constructed on time and within budget. Seebaran Sweet was also the first woman on the board of the Trinidad Publishing Company Limited. As chair of ASPIRE, Advocates for Safe Parenthood, Improving Reproductive Equity, she brought into the public domain debates around a woman's right to choose. Seebaran Sweet has played a crucial role as a conduit for public education, breaking down the law in a language that we all understand so that we know what is at stake. She has spent decades of her life fighting bravely and speaking out fiercely for women, children, and all vulnerable groups in our society. She has advocated with passion and compassion. Chancellor, for these acts of courage, service, and vision, I present Mrs. Lynette Seebaran Sweet and ask that by the authority vested in you by the Council and Senate of the University of the West Indies, you confer on her the degree of Doctor of Laws honoris causa.
by the authority vested in me by the Senate and Council of this university, I now confer upon you the degree of Doctor of Laws, honoris causa, of the University of the West Indies. I now invite Dr. Lynette Seebaran Sweet to address the company.
Chancellor Mr. Robert Bermudez, Vice Chancellor Professor Sir Hilary Beckles, Pro Vice Chancellor and Campus Principal Professor Brian Copeland, university executives and other members of staff, fellow graduates, graduating class of 2021. May I start with expressing my humblest appreciation of the recognition accorded to me, and by extension the women's movement and the legal fraternity of Trinidad and Tobago, on the occasion of this award to me of an honorary Doctor of Laws. In doing so, it would be appropriate for me to refer to the mission and core values of the university as articulated in its 2017 to 2022 strategic plan. A mission described as linked to the university's overall vision of excellence to advance learning, create knowledge, and foster innovation for the positive transformation of the Caribbean and the wider world, and espousing such values as integrity, excellence, gender justice, diversity, and student-centeredness. In this regard, I would like to acknowledge the university's teaching programs in history and social and political sciences, the arts and humanities, and particularly in the work of the Institute of Gender and Development Studies and in the Faculty of Law, where specific courses on gender, human rights, discrimination, constitution, and family law are taught. The university can thus be seen to be exhibiting its stated core values of gender justice and diversity. I am proud to be a past student. On an occasion such as this, I will take the liberty of briefly sketching out an outline of the women's movement in Trinidad and Tobago as I experienced it, taking a rare opportunity to pay tribute to many of the stalwarts, individuals and organizations working in gender justice, with whom it has been my privilege to collaborate since the decade of the 80s and up to the present. Many names come easily to mind, such as our late First Minister of Government with responsibility for gender affairs, Elmina Clark Allen, under whose auspices Trinidad and Tobago acceded to the Convention on the Elimination of Discrimination Against Women, CEDAW as we know it. It was under her guidance that the short-lived National Commission on the Status of Women was established and on which I had the privilege of serving. Mention must be made of the late Wilbert Permel, former St. Augustine Campus Registrar, who, along with myself, Jackie Burgess, Dennis Hyacinth, and others, led Aspire through its decade-long campaign for sexual and reproductive health and rights. It was during Aspire's tenure that it was clarified that despite the criminal provisions in the Offences Against the Person Act, it was lawful in Trinidad and Tobago for a doctor to perform a termination if, in his clinical judgment, it was necessary to preserve the life and the physical and mental health of the pregnant woman. It was during this period also that the Caribbean Association for Feminist Research and Action, CAFRA, was formed as a regional organization under the auspices of UN Women, the Trinidad branch of which was most latterly led by Tara Ramutar, who we recently lost. This was the era of the formation of such organizations as Women Working for Social Progress, led by the likes of Merle Hodge and Rhoda Reddock, that Diana Mahabia Wyatt founded the Coalition Against Domestic Violence, now ably visioned by another stalwart, Roberta Clark, late of UN Women, and working in tandem with the Rape Crisis Society. Organizations such as CAISO, led by the late Colin Robinson, focusing on gay rights and always operating in solidarity with the women's movement. Hazel Brown, another colossus, continues to head the network of NGOs for the advancement of women. Fulade Mutota of WINAD and Grace Talma must also be mentioned. Indeed, such was the collaboration between the interlocking network of NGOs that it was difficult to tell where one organization ended and the other began. Terry Innes has more latterly taken up the challenge to form and lead the CEDAW Committee of Trinidad and Tobago, CECOT, whose principal mission is to push for the fleshing out of Trinidad and Tobago's obligations under the UN Women's Convention. Gayatri Pagas has worked diligently over the years to birth various items of legislation in the field of gender and family law. To this long list of networks, I must add kudos to the board and management of the Equal Opportunity Commission, where I served over the period 2014 to 2020 alongside Drs. Beverly Beckles and Emmanuel Hussain, Colin Cowie and James Chinchuk, and with the devoted leadership of CEO Devanti Dayan Maraj Ramdeen. It is always a challenge meaningfully to address a gathering such as this, comprising the best and the brightest academically of our society. Should one adhere closely to one's sphere of putative knowledge and experience, that is to say, the development and practice of family law, gender and development, human rights and non-discrimination, and advocating for the rights of disadvantaged groups, such as the differently abled, the LGBTQI community, those stigmatized by the contraction of HIV/AIDS, and victims and survivors of gender discrimination and gender-based violence. Should one address the broader national or indeed global challenges of the day, climate change, environmental degradation, poverty, pandemics, racism, war, religious extremism. So many of these intersect with the issue of gender justice that it would perhaps be a conceit to attempt a separate treatment. I was fortunate to come of age in an era which witnessed and to participate myself in monumental legislative advances concerning the status of women, girls, and children in Trinidad and Tobago. Women had already enjoyed adult suffrage since the 1940s and did not suffer from some of the more egregious impediments to the rights to property ownership, the exercise of civil and political rights, and bodily autonomy experienced by many women in other societies. For example, 1973 saw the introduction of a new divorce regime which equalized the grounds upon which men and women could seek divorce, and introduced the concept of consensual divorce and a fair sharing of matrimonial assets upon marital breakdown. 1981 saw the introduction of the Status of Children Act, giving explicit recognition to the social reality of the then approximately 40% of children born outside of marriage, creating various methods of establishing the paternity of such children and thereby pinning the responsibility for their maintenance in the appropriate quarters. It was a bold move at one stroke of the parliamentary pen to abolish the status of illegitimacy, primarily a property concept, by equating the inheritance rights of all children, whether born within or outside of wedlock. The Family Law Act abolished the domicile of dependency of married women, which prevented them from filing for divorce in their chosen country of residence upon separating from husbands living in another country. This act also codified the welfare principle in the court's adjudication on children matters and equalized the rights of mothers and fathers to the custody of their children, whether born in or out of marriage. 1986, importantly, saw the abolition of certain discriminatory rules of evidence relating to the evidence of women in sexual offenses, such as the rule of recent complaint and the rule requiring corroboration of the victim's evidence. 1991 saw the introduction of the Domestic Violence Act, later revamped in 1999 and again in 2020. 1997 saw the introduction of the Cohabitational Relationships Act, which gave further recognition to our social realities in the creation of a right to a financial award upon the dissolution of a cohabitational relationship, which had lasted 5 years. In 2000, Part 8 of the Succession Act was proclaimed, revolutionizing the law of inheritance for those who did not leave a will by increasing the surviving spouse's portion from 1/3 to 1/2, and creating a right for a broad category of dependents who could challenge both the terms of a will or the rules of intestacy on the basis that reasonable provision had not been made for them. The period of the late 2000s saw the introduction of the package of children legislation, operationalized in 2012 with the setting up of the Children's Authority. We are beginning to see the fruits of this package with the increasing frequency of reports in the newspapers of persons charged with various sexual offenses created in the Children Act, including inappropriate touching. Most recently, the Miscellaneous Provisions Marriage Act has standardized the age of consent to marriage at age 18, replacing earlier ages for marriage, depending on religious persuasion or the common law. In 2004, a family court project was initiated in Port of Spain, and in 2016, the Family and Children Division Act created a separate division of the High Court. Other family courts recently rolled out in Tobago and Princestown. Sadly, though, these courts are woefully under-resourced, with the average period between adjournments in family matters now running at 9 months. One of the last official acts of the Equal Opportunity Commission, before I vacated office in 2020, was to work with the Attorney General and other stakeholders in the drafting of sexual harassment legislation, which hopefully will shortly reach to Parliament. But of course, we all know that the passage of legislation by itself is not sufficient to remedy society's ills. This requires a progressive vision for the society, a frank and data-informed assessment of societal challenges, consultation and policy formation, public education, and the commitment of the necessary resources to provide services and bring about normative change. Much of this is sadly lacking. As the mother of an adult daughter who lives and practices abroad, and as a soon-to-be grandmother, fingers crossed, I would like to describe the kind of society that would ideally greet them on a return to Trinidad and Tobago. A society which has sufficiently matured politically and which has risen above the challenges associated with its plural nature, so that there is a shared vision for development, opportunity for all, and a recognition of the steps needed to remedy the systemic historical ills engendered by the circumstances of our arrival on these islands. A society which develops a progressive vision and engages in rigorous forward planning for the best and highest use of its natural and human resources. A society which recognizes the global challenges of climate change, environmental degradation, globalization, the brutalist forms of capitalism we observe in our metropolitan neighbors. A society which is committed to eradicating poverty, giving land to the landless, fostering a spirit of mutual help between groups, of entrepreneurship and innovation, and which is committed to seeking meaningful reparations for the ravages of the transatlantic slave trade. A society which tackles head-on the need to revolutionize our educational system from the earliest stages to equip our peoples to participate in the fourth and the emerging fifth industrial revolutions, the digital age, the age of robotics, and the age of burgeoning technological innovation. A society genuinely committed to gender justice and gender equality, such that we routinely socialize and educate our children away from harmful and restrictive gender stereotyping, where we develop systems and mechanisms for training all groups into recognizing the benefits of family formation, family preservation, respectful relationships, and a recognition of the evils for children of family breakup. A society with a sensitive and well-resourced family court and family support systems with adequate social safety nets for vulnerable groups. A society which has created the mechanisms where women and children can safely exit abusive relationships and find secure housing for themselves and their children, and where their needs for jobs, job training, and childcare are catered for. A society which facilitates the recognition by and accountability for their behavior on the part of intimate partner abusers. a society which has reformed laws such as the Equal Opportunity Act and the Domestic Violence Act, which currently discriminate against persons on the basis of their sexual orientation by failing to provide the remedies created by these acts. A society where religions across the board recognize and remedy the historical harm of their patriarchal teachings, which foster discrimination against women and which have enabled centuries of sexual abuse and child sexual abuse. A society where women benefit from laws and have access to information and services which encourage them to postpone sexual debut until consolidation of their life skills, which enables them to plan their families, to guard against the incidence of unwanted pregnancy by the uptake of contraception, and where they have the full range of pre- and postnatal care and agency in the number and spacing of their children. A society where the evils of sexual harassment in institutions, on the streets, in the protective and caring services, in public transport, and in the workplace are acknowledged, planned for, and where remedies are created to compensate, protect, and support victims and survivors of this evil of sexual harassment. This then constitutes my vision for beautiful, talented, brilliant, fun-loving, diverse, innovative, open-minded, hospitable, humorous, proud Trinidad and Tobago. I would like to acknowledge the support of my colleagues in law, my mother, my beloved deceased father, my 4 sisters and 3 brothers, my daughter and stepson, and last but not least, my husband, Professor Emeritus Engineer Winston Herbert Edward Sweet, in whose aura of love, encouragement, and support I have been able to thrive and achieve over the past 45 years. In closing, it is with a spirit of humility and gratitude and expressly acknowledging the collaboration and input from all those numerous actors enumerated above, and with the best wishes to the graduates and the heartiest of congratulations to my fellow awardees, I proudly accept this award of Doctor of Laws from this my alma mater, the University of the West Indies, St. Augustine campus.